there, and welcome to the Seven Figure Authorpreneur Podcast, where we empower authors with tools, resources, and inspiration to build prosperous book brands. I am your host, Octoryia, and today, guys, we have the privilege of interviewing Shaunette Stokes. How are you?
I'm doing well. Thank you so much for having me, Octoryia.
I was so excited, guys. I forgot to say my last name, but today our topic is going to be how to protect yourself when writing nonfiction content. Can I get an amen? I am sure you are like, wait, let me pull over. This is it. I've been struggling. I'm not sure on this, that, or the other. And we hope today's conversation will really empower you, inform you, and inspire you to do what you have to do to make sure you protect your content. Let's get started. Shaunette, could you please explain to us, just to start out, what's your expertise as an attorney?
So I dabble in a few areas. I do practice intellectual property law. So that includes trademarks, copyrights, that's trade secrets, and trade dress. I also review and draft contracts. We do estate planning and probate, and we also do civil litigation and personal injury matters.
Wow, and how long have you been practicing law?
It'll be 9 years this month. My lawyer anniversary is in April, so 9 years.
Whoa! Happy lawyer
Feels like
anniversary
yesterday.
soon here, right?
Yes, thank you so much.
Oh my gosh, guys, I'm telling you, this is a blessing to have Shaunette on our podcast today. I'd like to also share in saying that she's actually working with Dream That Big Publishing in a few of the ways she's described. We have her working with on some of our intellectual properties that we want to get assets rather that we want to get protected, and we have her working on and reviewing contracts for us. So I'm not just interviewing her for interview's sakes. We actually trust and do business with her. That's why I'm so excited to share her knowledge. Now, my next question is this: what should an author be on the lookout for when signing a publishing contract?
So first and foremost, when you get a publishing contract, I would first, of course, recommend that every author reviews that contract on their own. But the next step, of course, is to forward it to an attorney, because most attorneys do have the eye that, we're looking for specific clauses. But if you are trying to make sure you understand that contract and you want to make sure that you know what clauses to focus on primarily, I would say look for the rights that are granted in that contract, any royalties, any advances, the duration of the agreement, and also look at the termination clauses, because you want to make sure that your contract doesn't get automatically terminated based on any actions that you are taking, or any inactions as well that you're taking. So you want to make sure that when you're reading that contract, be sure that you are upholding your side of the bargain as well.
That's so good. I love how you led with read the contract first for yourself.
Yeah.
Now, if we could explore that a little bit more, because I know just in my conversations with authors, even before I became a publisher, many feel overwhelmed. A lot of contracts are like 18, 20 pages long, and people want to commit to reading it, but they feel like
Right.
I'm reading it in complete ignorance. What would you say to them?
Right. I would say read it several times over, because you have to make sure that when you understand certain parts, and if you don't understand it, that is okay. That is why you have your attorney on hand to essentially translate the terms to you, because that's what we will do. We will say, okay, well, this is what this means in layman's terms. But you need to make sure that first you go through that contract and understand what portions that you do understand. And if there are portions that you do understand and you're uncomfortable with, be sure to highlight those, because as an attorney, I always tell my clients when they come to me, okay, what parts of this contract do you already have issues with? And then we couple that with the parts that I have an issue with. And then we take those two together and then we go into negotiation. So I need to know when the client comes to me what I need to be looking out for because I only know what makes you comfortable at the end of the day, you know? So they I tell the client read it 2 times 3 times over because it's very important that you at least become comfortable with what that contract is saying even though you don't understand all of it.
This is so good, guys. And I'm just hanging out here for a little bit because this is a big deal. I actually know of someone who signed a publishing agreement with someone, and because they read but didn't understand what they read, they ended up signing over the rights of all of the actual content. So the publisher then went on to publish the work as their own. Now
Mm,
you may be saying, well, that don't even make any sense. Who and how could you ever miss this? I'm gonna tell you right now, this is a very smart, intelligent person, but they didn't understand the language. So they
yep,
signed it, and the next thing you knew, their book was published under someone name other than theirs. Thank
yep,
God
I
they were
believe it.
able to litigate afterwards to regain rights back to their own work. But this is why we're discussing it because we're hoping that you will not make a similar mistake because you will take the time to read your contract, and if you don't understand, consult an attorney. Was there something else you wanted to share to that point, Shaunette?
No ma'am, you hit the needle on the head with that one. Absolutely. Because those things really do happen, you know. Most often I have clients that come to me and say I didn't know what I was signing, and the onus is on you to know what you're signing. They don't When you're entering into a bargain, the other party does not care if you have an attorney. That's not their job. Their job is to make sure that their interests are protected, and it's your job to do the same.
Wow. So just going a little further now into just understanding what protections are provided to authors, could you describe what laws are out there that protect our rights as authors?
The laws specific One law specifically protects authors is copyright laws, and authors should lean heavily into that. I always tell creatives, even if you're not an author, if you're just creating things, you want to put yourself on a quarterly schedule to protect your copyrights. So that means that if you are creating, say, poems or different um, bodies of work, every quarter you're submitting those bodies of work to the Copyright Office. It might become costly, but that is a budget that you should set for yourself. Every copyright application costs $65, um, $65 to file. And some works you're allowed to copyright multiple works on one application, and there are some that will only allow you to copyright one body of work. So you want to make sure that you don't or do fall under those exceptions, and you would want to go to copyright.gov to determine whether or not your body of work falls under the exception of allowing you to apply for multiple bodies of work on one application.
So what rights does copyright give an author?
So, copyrights allow you to, of course, produce the work and reproduce the work in different formats. So, for instance, if it's a book and you own the copyright, you can now create derivatives of that work. So, you can create a stage play, you can create a movie, and you are able to allow other people, say a producer or director of a movie, to use your book in this movie. So you would do it by way of licensing. So that is how most directors or Hollywood gets access to these books is by way of licensing.
And something just came to my thought actually on that topic. What How rather would copyright work for those who are doing a collective body of work as a book, meaning they're like 10 authors working together on one subject, but there was one main person who had the idea?
They would first want to enter into a joint venture agreement, and that joint venture agreement will first outline the entire scope of the venture and everyone's obligations under that venture and ownership terms. So, under the joint venture agreement, it would spell out who owns what portions of the book is owned by one individual versus the other. And then when you are applying for it under copyright, on the copyright application, you would just list the multiple authors and you would tell the copyright office which portion of the compilation of the book that each author contributed to.
Guys, you want to make sure you take note of what Shaunette just said. I recently was presented with an opportunity to have a collaborative publishing project with some other leaders in the area. And when I read the contract, it actually spoke to the fact that the person who's organizing it owns completely all the rights. And had I not read it, I wouldn't have been able to go back and negotiate in ways that Shaunette was speaking. I was able to go back and say, hey, unfortunately, I'm unwilling to give up the rights to my intellectual assets in this way. Because when I read it further on, this is the truth, it went on to say that you can never basically publish anything that you put there again once you turn it over into this book. And I was thinking like, but I talk about that all the time. Hence why it's so important to read your contracts. Wow. Is there anything else you wanted to share there?
Oh no, that was it. That was it.
I know you're probably saying I got all these messed up examples, but I'm sharing it because
No,
I
these are
want.
good examples. I love the examples because people need to understand that it's not just me speaking legal talk. These things really do happen in real life,
They do.
and you witness it, you know?
So now there are some instances as nonfiction authors, we are inspired by the work of others. So I want to make
Uh-huh.
sure we address this question. As a writer, do you need authorization to use a work protected by copyright?
Absolutely. So you want to let's start off as not just a writer, but as anyone. You want to make sure that you get the full permission of anyone's work that you're using. And there are, of course, exceptions to copyright rules or the laws, and that is called fair use. The fair use doctrine allows you to use copyrightable work under certain circumstances. And with fair use is a defense. And I always say with fair use, it's just like with stand your ground, unfortunately, in Florida, right? You don't want to have to use stand your ground until you are in the position to use it, right? So, what that means with copyright law, you are going to be sued if you have to use fair use as a defense. And that means that in the event that you say, okay, I'm using this work because it falls under the fair use doctrine, that does not mean that you have the automatic right to use it. That means that it's a defense in any copyright infringement lawsuit. So it's up to the judge to determine whether or not your use of that work falls under fair use. So I always say, just going back to the original question, do you have to ask for permission? And yes, you have to absolutely ask for permission, even if you're reposting someone else's work on social media. And that means if you're not an author, if you are just a creative and you're just reposting an image, you can get in trouble. I've had a client that got in trouble for reposting someone else's image on their social media pages, a photographer's image, and she even cited the work. And the photographer still felt compelled to sue. And they still had grounds to sue her because she posted their image, including citing the author on her social media page, but she still was not able to do it without his permission, you know? So I always tell everyone, get permission first. Bottom line.
Okay, so I guess in my brain, I'm thinking, and I'm sure listeners are like, well, when I was in school, I would cite things from works I read all the time. And all I did
Mhm.
was have a reference page, do the in-text citation, and it seemed to never be any issue. Is there a distinguishing difference when you get into the publishing world?
No, so fair use does, for educational purposes, that is fair use. So if you're using copyrighted work for educational purposes, you can very well use that under the fair use doctrine. So no one's going into the schools trying to sue students for citing authors' work. So no, education does fall under fair use. So if I am teaching something and I wanted to play a video or a movie, I am able to do so because of the fair use doctrine, which is education.
Wow. So
So
how
there are certain things that just fall under fair use that people are just like, okay, I'm not going to sue, like educational things.
how would an author go about gaining permission from John Maxwell to use his quote?
Well, you want to make sure that it sounds like a science to it, but you want to first see when that quote was published, right? And if the quote was published during the time that the copyright still exists, because copyrights expire as well. And also the laws have changed. So there are certain copyrightable works that have fallen into the public domain. And the public domain allows, it's like a free for all. You can use it without the author's permission. But you want to, one, first check and see if that work is in the public domain or if you need the permission. And if it's not in the public domain, you want to, at the very least, go to the publisher. So if you know that author has been published by a specific company or organization, you want to reach out to them first to see if you can obtain the rights or a license to use that specific quote.
That's so good. Do you see why we need attorneys, guys? Because we could keep asking more and more and more questions, and it's all leading back to having access to someone with that on point knowledge to help guide us in making the best decisions for what we're doing and hoping to do in the future. Now, I know we've tossed around the word intellectual properties a few times, so I think it might be beneficial for our listeners to go ahead and define it. And even going further, what do authors need to know about intellectual properties?
So intellectual property is, of course, property that is not necessarily tangible, but it can be tangible. It starts in your head first as an idea. And once the idea becomes in a tangible form, that is where it becomes intellectual property. So you have different types of intellectual property. You have your trade dress, and trade dress is a 3D logo or packaging. And that is, and you could also protect the way that a restaurant's laid out. So the layout of a restaurant, that's under trade dress protection. Trademark is your service mark and your goods. That's all under trademark. So that is protection of the brand name, your slogans, your colors, certain sounds. That all falls under trademark. Copyrights are your creations, things that you are able to touch. That could be a book, that could also be a sound or a song, that could be a sculpture, a photo. Those all, and even blogs and software fall under copyright law. Then you have trade secret. Trade secret is Coca-Cola is a good example of a trade secret, or Bush baked beans. These are your recipes. These are things that you want to maintain as a secret. So you're protecting it under contract law as opposed to filing for a specific protection under a different law, such as the USPTO for trademarks and patents. And finally, you have patent law, which is your inventions. And that is a separate set of skill set for an attorney. Those attorneys that do practice patent protection law, they have to have a specific scientific or a mathematic background, educational background for them to even sit for the patent bar. So you have to be licensed within the USPTO to even practice patent. So that you will often see that a patent attorney only practices patents. So most trademark attorneys only practice trademarks, and you'll have some that do the entire realm of intellectual property as well. So I would classify myself as a soft IP attorney. So no patents, just the trademarks, copyrights, trade dress, and trade secrets.
Wow, so good, guys, right? I bet you she's listed at least one thing that you're like, I need to do a little bit more research on what it is. Hence, again, having an attorney working with you in your process is very, very important to make sure we're not ignorantly or innocently making errors that will come back to haunt us. Now, Shaunette, I think what is very, very important for us to address next is the fact that we often work and have conversations with people who publish nonfiction work based off of real people, real life, all that kind of jam. And most of us feel it's okay to just talk about it because that's what we do. But
Mm-hmm.
when you're writing a book, how do you use real people in your writing without ending up in court for defamation?
I would be very, very careful with disclosing private information about other individuals without their consent. So I would first ask everyone, all parties involved, for their consent if you're going to use names. And if you choose to not use names and for the privacy of those individuals, then you would want to at least use a fake name so that that person cannot find out who you're speaking of specifically. If you don't get the permission of that person and you're still using their name, that may lead to an invasion of privacy claim, and you want to try to avoid that.
So I just had to sit there and think because we actually were at a mixer again and someone asked about, can I write my story about being violated by a person, but don't use their name, just
Mm-hmm.
make up a fake name. And I had always been under the impression that if you're using someone's likeness or image,
Mm-hmm.
that still required permission, but
Yeah.
they can use a fake name and still tell their story, even though it's can be super clear, like super easy to identify that they're talking about their mom.
Yeah. So you can, well, yeah, that is a very tricky way to go about it because, of course, when you're speaking of your mom, there ain't no other way that you can say that's my mom. And choosing a different name, we all still know who your mom is, right? I would I would say that they're going to run the risk of if that person feels so compelled to sue them, they're very much so going to run the risk of either a invasion of privacy claim or a defamation claim. And if it's a defamation claim, then they have to prove the onus is on the person that's bringing the suit that the individual was lying. So if they can prove that that person lied, then they'll win the suit. But the entire point of a defamation case is to prove whether or not that statement was factually accurate. And if that statement was accurate, then that honestly looks bad on the person that's bringing in the claim because now if they bring out that all of this information is correct, then that person absolutely has the right to tell their story.
That's so good. And something just came to my mind, guys. I know I'm all up in y'all Kool-Aid. How what makes permission to publish people in your book valid? Is it just a conversation or does it need to be more formal?
Yes, thank you for asking me that. It definitely needs to be formal because you want to make sure that that other person doesn't renege. And how do you prove that that person said that they were going to allow you to use their likeness in the book other than by way of a written communication and a signature, right? So, or even an email. An email would suffice if you emailed that person and said, hey, I'm considering using you in my book. Attached is the proposed manuscript. Please let me know if you approve. And they say, absolutely, I approve. Then that would be sufficient as a release, so to speak. But I would go so far as to actually have an attorney draft up a release so that that person knows that one, they can't sue me, and two, you can't get royalties off of my work for using your likeness in my book. So all of those terms would be spelled out in a contract so that it makes the author comfortable using someone else's likeness and knowing that that person cannot come back and try to receive monetary compensation based on the use of or any portrayal of them in that book.
That's so good that you touched on the royalty sides of things. I think sometimes as authors, we look at, especially self published authors, we're like, oh, we're just local and little. But a lot of people
Mm-hmm.
started local and little, but blew
And
up.
little, yeah,
And if you're not protecting with a big vision in mind, you're going to set yourself up for future lawsuits. Because once
absolutely.
people now see you're catching fire, you're everywhere, you're selling a lot of books. Now they want to call your card and say, "But you never asked me to do X." So it's better to begin this with the end in mind. Get it legally handled as though you're already a best-selling author. I cannot stress this enough. Handle it,
Mm-hmm.
and please, guys, trust me, I have been there where I haven't had money and resources were tight. And so I Googled a lot, but you are playing with fire by Googling contracts and using them
Mm,
as your own. Could you speak to that?
absolutely. Yes, because thank you for saying that because contracts are not one size fits all. What is going to work for you, Octoria, is not going to work for the next publishing company, right? And what is going to work for you as an author is not going to work for the next author. So everyone needs to take a step back and try to stop using someone's contract off of the internet and really sit down and determine what does the ideal transaction look like, right? And then think about all of the terrible things that could go wrong. You don't want to take your mind there in terms of what will go wrong, but what can go wrong. And when you frame your mind in that way, you're able to take yourself out of the equation and really look at it from an objective standpoint. And then you can think of different terms that you can put into a contract that will prevent those things from going wrong. Because especially if you are an author that has, you know, worked certain deals before, you know you have that experience and you've seen what has gone wrong and you don't want to repeat those circumstances again.
Girl, you just got my mind just getting triggered in so many ways with so many real life stories. And I think this one's going to be really important for someone to hear today as they listen. I had someone who eventually came to do some work with us as a publisher. But by the time they started working with us, guys, they had already signed 3 publishing contracts prior to us, fully paid for them. And I'm here to share with you, they didn't have even one book published. And
Oh,
it was
wow.
kind of like mind blowing to me. I'm thinking, like, the math ain't adding up. You've got
Right.
3 contracts, but no books. See, what happened is, going back to an earlier point, they didn't read the terms of the contract. And the
Mm-hmm.
terms of the contract required them to be done in 6 months. And if they weren't, it
Mm.
released the publisher from any responsibility or liability of working with them on the project. Guys,
Wow.
listen to me when I say all of which we're speaking of, from Googling contracts to understanding contracts to working with attorneys, is for your benefit. You may be thinking, I'm just a regular person writing a book. I don't need all that. Trust me. It'd be better that you have it and don't need it than you need it and you don't have it. Wow.
That goes back to the conversation that we just had about reviewing that contract and knowing what that contract says and knowing the obligations that you have to uphold. Because a lot of people read the contract for what they're going to get out of the deal, right? So, what am I going to get? But you often have to make sure you know what you have to put in to get that return. And that is what most people miss in every contract is their part of the deal. They're always waiting like, okay, I'm waiting for, this other person to fulfill their bargain and they're waiting for you to
Exactly.
fulfill your side, right?
Yes, guys, listen, while we are definitely having a fun conversation, this is a very, very, very serious topic. And our hope is that things that are being discussed and shared will raise the awareness and responsibility that you have as an author to think big picture and get and consult with an attorney to make sure legally you are covered in the areas you need to. You know what you're signing, you're set up for success in the future. And that leads me to one of my final questions. Shaunette, can you give us three legal issues all authors should be aware of?
You should certainly be aware of copyright infringement, of course, because you want to make sure that you understand what you can and cannot do. And contract matters, contract specifically, contract breach issues, and royalties. How do royalties work for authors? These are things that you certainly want to look into as an author.
So good. So good. And if I could piggyback on there, especially when it comes to royalties, guys, please stop expecting
Mhm.
other people to make it make sense to you. I never forget when I was in leasing, I got in trouble because I used to go in those units and find things that were very obvious to me that were wrong in the unit prior to people moving into the apartment. But
Mhm.
the company started noticing all my work orders for move-in inspections were way longer than anyone else's. So they sent the manager to observe what I was doing. And they saw I'm out here pointing out this, that, and the other. And I got pulled into the manager's office and she said, "Stop doing that." I'm like, "Why?" Because it's not your responsibility. Even though I see it, know it, and can help with it, the responsibility rested on the resident to look in detail and find anything that didn't make sense. The same goes with your contracts, guys. You need to make sure you're paying attention. And if you don't understand, as we've admonished you to, get with an attorney that can help have those eyes, have that knowledge, have that expertise, and help shorten your learning curve and make sure you don't
Mhm.
jam yourself up into something that's not going to serve your future well. Shauna, I know we could keep going on and on because this is
Yeah.
such a big, vast topic, but I want to leave our listeners with a resource that you could offer or point them to continue to grow in this area.
There's a few resources that I could offer. Some of them, of course, are not plugged by me specifically. Copyright.gov. That is, a lot of people don't realize that you can literally go on the copyright website and they have a lot of resources, educational information on there. It is more informational and straightforward than the trademark office. And I always tell people that if you are a creative, I empower them to understand copyrights, because that is essentially something you need to do on your own, and leave it to the attorneys to police the copyrights. And then I would also say you can go to my website. I have a lot of resources on my website about different types of intellectual property. So stokeslegalcounsel.org. So those are two resources I would suggest. And then one last one, the Authors Guild. Authorsguild.org is another one.
Very good one. All right, now, guys, you know what time it is. It's time for you to implement, execute, and as a result, we believe we're going to prosper together, authors. Talk to you soon.